Last night, August 6, 2026, the president dropped two new executive memos ending birthright citizenship. One of them is called Ending Birthright Citizenship, and the second one is Continuing to Preserve the Meaning and Value of American Citizenship. Both of these memos have far-reaching implications for people who are applying for visas and for people who already got their green card. There are lots of clients who are currently on the plane coming into the United States right now. So I've been up since 2 a.m. working with the AILA liaisons on the East Coast, as well as people who are here on the ground and trying to contact the CBP officers at LAX. We're going to unpack these two memos and all the implications. I know it's really new and I'm going to be talking a lot more about it in the weeks to come, but here's everything that we know so far and a lot of things that most people don't know. But here it is. Let's go. Number one, even if the parents are already green card holders now, if back then, when they were just a tourist, they gave birth and their children was a US citizen and they went through the birth tourism pathway, there is a possibility a custom officer will not let them into the United States and deem them inadmissible. Or even worse, if an ICE agent or a CBP agent catches somebody who is a green card holder, looks into their past and finds out that they gave birth in the United States and they went through birth tourism and their children is US citizen, they can be removable. Now, this is going to be one of those things that's going to be most hotly contested and litigated, especially if the green card holders are here in the United States and they're in immigration court. But what about the people who've already left the US and, maybe they're on a reentry permit, they've been out for a year, 2 years, if they're coming back in and they have children who are US citizens and customs officer is digging deep and looking to that past, they now have that additional authority to deem them inadmissible because of the proclamation, right? It's written, it's stated in there. Now, this is the most consequential one. And this is the one that is going to be most hotly contested in the courts because essentially this proclamation created a new inadmissibility ground, a new ground where somebody can lose their green card status. Now, obviously, we haven't seen this happen yet. USCIS, CBP, Customs, they're all trying to figure out exactly what these proclamations mean and how they can implement it. But from the plain language of the proclamation, that is what's possible. Now, if the parents have already become a citizen, they might not be deemed aliens anymore, and so they may be protected. Of course, there's always a possibility the Department of Justice can go back and denaturalize them, but that's a completely different story. Right now, we're just focusing on the aliens, which means it's a green card holder or anybody else in other visa categories. Typically, you would think that a green card holder has already the highest protection, but according to this memo, that's still possible. So that's number one. Number two, this is really concerning because the federal government is not going to recognize local, state, and county and city proofs that somebody is a citizen. Meaning, in the future, there will be a situation where a child might have a birth certificate, maybe a city ordinance, a state government recognize them as a US citizen, provides proof that they are US citizen, but the federal government will not confer that benefit onto them, will not recognize that they are US citizen. That is going to be huge. Now, how far is this going to extend? Is it going to just extend to people who are born now, starting today, August 7th, 2026, going forward? People who are born, they might be able to get a birth certificate from the hospital. Maybe state and local ordinances give them the benefit of a US citizen. But if they're trying to apply for a passport or any federal benefits, or if they want to petition their parents in the future, the federal government doesn't recognize them as a citizen, that might become an issue in the future. Now, tangentially, what happens to the tens of thousands of children who are born here and who have citizen, who have a passport? And what if their passport expires and they are now up to renew their passport? And when the State Department or the consulate is reviewing their application, they go find out, oh, your parents are not green card holders or citizens, they will not continue to reissue that renewal. Because a passport is only an evidence of your citizenship. It isn't actual proof that you are a citizen. Even if they have a birth certificate that shows they're a US citizen, government agencies, the consulate, as well as the federal building, the passport agencies, when they're reviewing these, they could say, well, you need proof of your parents to be a citizen, or you might need proof of consent from both parents to be physically here to continue to renew your application. They can create these bureaucratic steps in order to issue the passport. And that's going to be another area that is going to be hotly contested. Number 3, are we going to see more and more situations where people have to show up at the border, whether it's Canadian border or the Mexican border, with only their birth certificate? Because the hospitals will still issue birth certificates. And if you're under 16 years old at the land border with a birth certificate, a lot of times a customs officer will use that as a travel document and let people in. And when I've seen it all the time, I go to Mexico almost bi-weekly basis, and I see this done very often. They don't have a passport, they don't have a travel document, they don't have a green card, they show their birth certificate. If a kid is under 16 years old, routinely, they use that, they admit them. Now, if you're over 16 years old, you show up with a birth certificate. They might be a little bit more strict, and I see them pull to secondary all the time to investigate, well, are you an actual citizen? That was, again, in the past. Going forward, based on this new memo, if they see, oh, your parents are not green card holders or citizens when you were born, did you go through birth tourism, and therefore, is your citizenship still valid? Therefore, will I let you in? That's going to be another area that we're going to see hotly contested if this goes into effect and if CBP and USCIS implements it. Now, when I was reading through this memo, there are certain things that I feel like should have been clarified. Number 1, for the past 6 years, people cannot get a tourist visa to come to the US to give birth. Birth tourism have been strictly outlawed and banned for the past 6 years very clearly. If your primary purpose and intent is to come here to give birth, the consulates will not issue those visas. And something else that most people might not realize, for the past 8 years, at least, we've seen plenty of parents who have given birth in the US and have US citizen children, when they go to their E2 visa interviews, when they go to their any sort of visa interviews, the consulate routinely denies them, saying you have immigrant intent. Therefore, we're not going to give it to you because you have a child who was born as a US citizen. Or they severely challenge them. How did you give birth? Did you use any benefits from the US? And if you did, then you violate that status. So the whole birth tourism industry has largely been shut down in the past 8 years plus. With that being said, there has never been something as clear as this, where it comes directly from the president and directly outlawing birth tourism and implementing it at the customs office, at the consulate, and with USCIS. And to the point where we're seeing, even if you've engaged in that conduct in the past, your visas can be revoked and you can be deemed removable, meaning you could be deemed deportable. This is extremely serious. It gives a lot of power to ICE, a lot of power to customs, and a lot of power to USCIS. Somebody might be here already on H-1B visa status, and they're about to get their green card, but now suddenly they have this new, quote unquote, inadmissibility, a new reason where the government can kick you out. So everything you've invested can be all null and void because of an action you did maybe 5 years ago, 10 years ago, 15 years ago, when it was perfectly legal. And that's the next thing I want to slowly unpack. Going to a country, giving birth is not illegal. It is not illegal on the criminal matter, and immigration is a civil matter, so it's also not criminal in a civil matter. But before I could continue talking about this, I want to talk about the concept that I've been getting a lot, where isn't this a violation of due process? How can you implement something now and say that what your action that you did was perfectly legal 5 years ago, 10 years ago, 13 years ago, somehow that is illegal? That concept only applies in the criminal sense. In civil situations, government can oftentimes create new laws that reinterprets an action that's done in the past. This happens in tax law, this happens in immigration law all the time. So it is perfectly within the government's ability. They are not going to be sued over this particular issue. It might be unfair, it might be harmful, there might be other public arguments as to why this shouldn't be the case, but it is definitely perfectly legal to reinterpret what birth tourism, the action of giving birth in the US, and its implication to all your future immigration actions. Now, going back to talking about birth tourism, there's also a difference between paying an agency defrauding the government at the visa interview with customs and with the benefits, coming to the US and using free benefits and giving birth and getting a citizenship out of it. Fraud and misrepresentation has always been an inadmissibility. It will always be an inadmissibility, and that has not changed. What has changed is now, well, what is birth tourism exactly? And all the people who are involved in this process. For example, if you're about to give birth and you hire an Uber driver, take you to a hospital, there's a commercial transaction. Did they facilitate in birth tourism? If you rented an apartment for 3 months or 6 months and then you gave birth, was the landlord involved in this? If the nurse is taking care of you while you are pregnant and then you give birth and your child is a US citizen, is the nurse liable in this accomplice? Should they be removable as well? Well, most people will probably say, of course not. That's totally not fair. They didn't know. So it will end up looking like it's going to be a matter of intent. If there is an agency that orchestrated everything, and if you are a nurse, if you are a driver, if you are a landlord, and all you do is facilitate in all these people coming over, and you knowingly knew that they are giving birth in the US, you could become an accomplice. That's going to be up for interpretation. That's going to be up for litigation as well, right? So the act of giving birth while not being in a permanent resident or a citizenship status, in any other non-immigrant status that is supposed to be temporary, including a temporary work, a temporary visitor, temporary visa, that action can now be construed as birth tourism with its immigration consequence of being denied future visas and or being removable. The immediate implication that most people will think of is that all the children who are US citizens, even if they continue to be US citizens and have all the privileges of US citizens, when they try to petition their parents, and the parents are going through their green card application at the consulate or in the US, US officers will review this application and say, oh, you engaged in birth tourism. That is considered potentially fraudulent. Now you have to apply for a waiver. But because waivers are only granted for immediate relatives that are spouses or parents, if your only immediate relative is your children, your spouse is not a US citizen or a green card holder, and your parents certainly are not green card holders or US citizens, then you do not even qualify to apply for a waiver, and therefore you can't get it, right? So this effectively could mean everybody who has given birth in the United States, whether or not you went through the birth tourism scheme that the US government is saying that is prevalent. Even if you came in, you found a doctor yourself, it was an emergency, but by the very act of being a tourist or in any other non-immigrant status and giving birth, that might prevent you from ever becoming a green card holder. Or if you've been a green card holder, might prevent you from becoming a citizen. And even worse, if you're a green card holder and you get detained by ICE, your green card could be confiscated and denied. All of these are implications of what this memo could mean. It's going to be heavily litigated in the next years to come to see exactly what extent does this push. But this effectively will probably stop all future birth tourisms. And this is going to have lasting implications to everybody who've already given birth, both for the children who have a passport and for the parents who are in the process of immigrating, whether they are on a non-immigrant visa right now or that they're already a green card and they're trying to become a citizen. These two memos is drastically different than the first birthright citizenship memo that came before, that got struck down by the Supreme Court, because that prior executive memo was trying to redefine and reinterpret the 14th Amendment. And it went way too far against the plain meaning of the 14th Amendment, according to at least most justices as well as the public. However, these two new memos hold a lot more water because it is redefining what is allowed to be a tourist. And that is within the presidential power. The president and the executive branch overseeing the consular affairs grants visas, can interpret what the visas mean. Tourism is very broad. And routinely, it has continuously changed in definition and what it allows and what it doesn't allow. And now these two proclamations have made it extremely narrow, saying you could come to the US for medical treatment, but if you're coming to the United States to give birth and they will get a citizenship out of it, that violates the meaning of tourism. And so we're going to restrict that, right? So ending that privilege. Now, if somebody is on a work visa and they've been here for 3 years, 5 years, 10 years, and they get pregnant and they give birth, is that birth tourism or is that not birth tourism? Not according to this memo, but we'll have to see how things play out, because according to the original that was struck down by the Supreme Court, they wanted to take away all citizenship granted to anyone and everyone unless they are a green card holder, unless they are a citizen, or unless they have an immigrant intent visa category, right? But like tourist visas, like TNs, they probably wouldn't have been granted the citizenship according to the first executive order. But now it is singling out birth tourism, so mostly tourist visas. But what about the people who did come, who did say to the consulate as well as the CBP, I'm going to the US to give birth. I planned everything out. I found my own doctor. I paid for everything. I'm not paying for this third-party service to arrange everything, to defraud. I was honest and truthful throughout the entire process. I even talked with a CBP officer before coming in to see if I can come in, and they approved it. If you are honest throughout the entire process, you paid for everything, is this still birth tourism? Based on proclamation by the president, they're trying to combat these third-party agencies and people who are defrauding the US. But what if you were truthful and it was legal? Because we know that that was the case. We know plenty of people who were honest with the consulate, who were honest with the CBP officer, who paid for everything, and who did not use any third-party agencies because 20 years ago, 15 years ago, 13 years ago, it was still prevalent and it was still okay and it was still accepted. It was only in the past 6 years, 8 years that we began to see this being more and more of a problem. And so this is going to be an evolving issue. We're going to be following this development very closely. I'm going to be personally talking to customs officer in the San Diego border. We're going to be talking to the LAX CBP officers with their annual meetings. We're going to be seeing and reporting what American Immigration Lawyer Associations is seeing and hearing from their liaison branch with the customs. And of course, everything we hear and we see and develop, we're going to be posting it right here. I know there's a lot more questions than there are answers right now, but I hope everybody prepares well. They don't get caught blindsided. And I'll talk to you soon, okay? Take care.